drafted a proposed new instruction. A few things I'll note, looking at the case law in the case, I'm citing a case Crawford versus State. And that's 160 Idaho 586 that indicates if a jury with its note indicates that there's any kind of a defect or gap in the instructions, then the trial court has the duty to give such additional instructions on the law as are reasonably necessary to alleviate the jury's doubt or confusion. I'll also note that Idaho Criminal Rule 30C states that the court may further instruct the jury after deliberations have begun, either in writing or explain the instructions in open court, and further instruction or explanation must be made part of the record. So we are going to put that on the record. In addition, Idaho Code 192204 allows for the jury to return after they've retired for deliberation to address a question such as the one that's been posed here by the jury foreperson. So in order to address the question, then I'll note on the record, I've advised counsel and shown them the question the court received. I'm going to have the jurors return, and the court has now drafted an additional instruction, which is jury instruction number 42. And that is an instruction relating to the elements as they relate to count 6 of the amended indictment. So beginning with the state then, has the state had an opportunity to review the instruction number 42?
Yes, Your Honor.
Is there any objection to the court reading that instruction to the jurors at this time?
No objection.
Has the defense been able to review instruction number 42?
Yes, Your Honor.
And is there any objection from the defense to the court reading the instruction at this time?
There is no objection to the court reading the instruction at this time.
Okay, thank you, counsel. We'll have the jurors return then, and that will include the alternate jurors as well. The court will go through the reading of instruction 42, and one additional original copy of the instruction will be provided to the jurors with their instruction packet, along with courtesy copies they'll have of this new instruction. So, Mr. Bailiff, if you would please have the jurors return to the courtroom at this time.
All right, please.
All right, thank you. Please be seated. All right, thank you, ladies and gentlemen of the jury. The court received a jury question from the presiding juror, and the question states as follows, quote, Judge Boyce, as to count 6, is there an instruction listing the elements? The court went back and reviewed the instructions you were provided, and despite best efforts to give you all the necessary instructions, in fact, you were not provided an instruction as you've requested and should have been. So for that reason, the court now is giving you one additional instruction that you may consider in your deliberations, and that is now instruction number 42. So the court will now read through instruction number 42, and after it's been read through, you'll be able to continue with your deliberations. So jury instruction number 42 reads as follows. In order for the defendant to be guilty of first-degree murder as alleged in count 6 of the amended indictment, the state must prove each of the following. 1, on October 18, 2019. 2, in the state of Idaho. 3, the defendant, Chad Daybell, engaged in conduct or did aid, abet, advise, or procure another to engage in conduct which caused the death of Tammy Daybell. 4, with malice aforethought. And 5, the murder was a willful, deliberate, and premeditated killing. Premeditation means to consider beforehand whether to kill or not to kill, and then to decide to kill. There does not have to be any appreciable period of time during which the decision to kill was considered, as long as it was reflected upon before the decision was made. A mere unconsidered and rash impulse, even though it includes an intent to kill, is not premeditation. Aiding and abetting is defined as follows: all persons who participate in a crime either before or during its commission by intentionally aiding, abetting, advising, or counseling another to commit the crime with intent to promote or assist in its commission are guilty of the crime. All such participants are considered principals in the commission of the crime. The participation of each defendant in the crime must be proven beyond a reasonable doubt. If you find that the state has failed to prove beyond a reasonable doubt any of the elements 1 through 4 above, or failed to prove any of the circumstances listed in element 5, you must find the defendant not guilty of first-degree murder. If you find that elements 1 through 4 above have been proven beyond a reasonable doubt, and you unanimously agree that the state has proven any of the above circumstances under element 5 beyond a reasonable doubt, you must find the defendant guilty of first-degree murder. If you find that the state has failed to prove any of the above, you must find the defendant not guilty of first-degree murder. If you find that all of the above have been proven beyond a reasonable doubt, then you must find the defendant guilty of first-degree murder. So that concludes reading of jury instruction number 42. The court will have you include that in your deliberations, and that original instruction will go back with you to the jury room for your deliberations. Thank you for your patience in addressing this matter, and thank you for the question to address that as well. All please rise for the jury then. All right, thank you. We're in recess.
Judge, is it still the court's position 30 minutes within notification?
I think so, Mr. Pryor. I think that helps
you, Your
us
Honor.
keep things moving if we have any other questions or a verdict.
All right. Thank you, Your Honor.
Thank you.